Hello, and welcome to JD Advising's California Bar Exam Essay Guide. The goal of this guide is to help you find an effective and efficient approach to the California Bar Exam essays right from the very beginning. This guide will help you feel confident on test day so that you can conquer the essay portion of the California Bar Exam. If you have any questions about this or other resources we offer for the California Bar Exam, please don't hesitate to contact us. Some of our other resources include a California Bar Exam prep course, private tutoring, essay feedback, and one-sheets. If you reach out to us, we'd be happy to speak with you about the resources that can best help you prepare for the California Bar Exam. We hope you enjoy this guide and good luck on the exam. Civil procedure is tested both on the multiple choice and essay portions of the California Bar Exam. It is worth noting that civil procedure was only added to the multiple choice portion of the exam in 2015. So it's possible that it would be tested less frequently on the essays now that it's being tested on the multiple choice portion. However, we haven't really seen a decline in the frequency with which civil procedure is tested on the essays since that time. This subject still appears regularly on the essays, but the good news is that it is somewhat predictable in terms of how it is tested. Let's talk about some tips for success on the civil procedure essays. First, learn and memorize the federal rules of civil procedure. According to the State Bar of California, both the Federal Rules of Civil Procedure and the California Code of Civil Procedure are within the scope of the testable material on the essays. So this is a subject where there are California distinctions that could be tested on the exam. However, California law is hardly ever tested on civil procedure essays. California law was tested on the July 2016 civil procedure essay and has appeared several times as a very minor issue within claim and issue preclusion. Otherwise, the civil procedure questions almost always ask you to apply the federal rules of civil procedure. So you shouldn't ignore the California Code of Civil Procedure, but you should certainly spend more time learning and memorizing the federal rules of civil procedure. As for a strategy for learning all of this law, we recommend that you learn the federal rules of civil procedure first. Then, after you're comfortable with those rules, work on learning some of the California distinctions. You should look at that July 2016 civil procedure essay to see how the distinctions were tested to get a sense of what types of distinctions you may be expected to know should California law be tested on a civil procedure essay. The next tip is to be aware of the highly tested issues on civil procedure essays. Some of the more frequently tested issues include personal jurisdiction, subject matter jurisdiction, removal, the Erie Doctrine, and claim and issue preclusion. Let's talk about these topics. First is personal jurisdiction. Personal jurisdiction is the power of a court over a particular person in a case. The requirement of personal jurisdiction arises from the Due Process Clause of the 14th Amendment. When this issue comes up, you should first discuss general personal jurisdiction and then analyze specific personal jurisdiction. Specific personal jurisdiction is tested far more frequently, but discussing both types of personal jurisdiction will make your answer appear more thorough. The traditional bases for general personal jurisdiction are consent, presence, and domicile. Consent can be express or implied. Express consent could occur, for example, if a person signs a contract in which they agree to be sued in a particular state. Implied consent could occur if the defendant fails to object in the first response to the plaintiff's complaint. Presence means that the person is either present in the jurisdiction when served or has continuous and systematic contacts with the jurisdiction. Finally, domicile can be a means of establishing jurisdiction both for an individual or for a corporation. An individual is domiciled where he or she is at home and where she intends to stay indefinitely. A person can only have one domicile. So if a person, for example, has a permanent home and a vacation home, the domicile is likely wherever the permanent home is. A corporation, on the other hand, has two domiciles. A corporation is considered domiciled in the state in which it is incorporated and also in the state in which its principal place of business is located. If there is no general personal jurisdiction by any of these means, next analyze whether there is specific personal jurisdiction. Specific personal jurisdiction must satisfy both the state constitution and the United States Constitution. State constitutional requirements are met if the state's long-arm statute is satisfied. California's long-arm statute grants the same amount of jurisdiction as the U.S. Constitution. So as long as the U.S. constitutional test is met, California's long-arm statute will also be satisfied. To satisfy the U.S. Constitution, the defendant must have engaged in such minimum contacts that it would not offend traditional notions of fair play and substantial justice. To determine if there are sufficient contacts, see if the defendant purposely availed himself of the benefits and protections of the state, such that it was foreseeable that the defendant would be the subject of a claim in that state. There are at least 3 sub-issues within this test that you should separately discuss: minimum contacts, purposeful availment, and foreseeability. Another sub-issue to discuss here is relatedness, which is about whether the contacts with the state are related to the lawsuit. Analyze as many facts as possible to fully discuss each of these sub-issues in your answer. Also, try to use as much of this key language in your essay answer as possible to maximize your score. The next highly tested issue is subject matter jurisdiction. Subject matter jurisdiction is the power of a court to hear a certain type of case. Generally, we're talking about whether a federal court can hear a certain type of case, since federal courts are courts of limited jurisdiction, which means that they can only hear certain types of cases. The types of subject matter jurisdiction include federal question, diversity jurisdiction, supplemental jurisdiction, and jurisdiction conferred by statute. Federal question and supplemental jurisdiction have only appeared a couple times on the California Bar Exam essays, but diversity jurisdiction is highly tested. Nonetheless, when you are discussing subject matter jurisdiction, you should discuss both federal question and diversity jurisdiction. You don't necessarily need to mention supplemental jurisdiction unless you have facts which necessitate a discussion of that issue. So federal question jurisdiction exists over cases that involve a claim that is either created by federal law or is created by state law but depends on a substantial federal question. The well-pled complaint rule states that the federal issue must appear on the face of the plaintiff's complaint. You should mention all of this in your rule statement for federal question jurisdiction. Diversity jurisdiction has 2 requirements. First, there must be complete diversity of citizenship between the plaintiffs and the defendants. And second, the amount in controversy must be over $75,000. Sometimes when subject matter jurisdiction is tested, you might also see the issue of removal tested. Defendants may remove a case from state court to federal court if the plaintiff could have initially brought the case in federal court. When can a plaintiff bring a case in federal court? When there's subject matter jurisdiction. So you can see how these 2 issues, removal and subject matter jurisdiction, naturally go together. Another issue that we've seen come up several times is the Erie Doctrine. This doctrine states that when a federal court is hearing a case in diversity jurisdiction that arises under state law, that court is required to apply the substantive law of the state and the federal procedural law. Every time this has been tested on the California Bar Exam essays, the issue has been the right to a jury trial. So it's a situation where, for example, the state might allow a jury trial, but federal law would not. So which law applies? Well, the right to a jury trial is considered a procedural issue, so the federal law will dictate whether the parties are entitled to a jury trial. The final highly tested issue that I want to discuss here is claim and issue preclusion. Claim preclusion prevents a plaintiff from retrying the same cause of action in a later lawsuit where there has already been a final judgment on the merits. The elements are same claim, same parties, final judgment, and on the merits. If these elements are met, the plaintiff will be barred from retrying the case. Issue preclusion prevents issues that were actually litigated, actually decided, and essential to the judgment in a previous action from being litigated again. Issue preclusion tends to be the more confusing concept, so I'll give you an example. Let's say that a plaintiff sues her employer, claiming that she has not been paid the overtime wages she is entitled to. Her employer argues that she's just an independent contractor, not an employee, and so the plaintiff is not entitled to overtime wages. The court agrees with the employer that the woman is just an independent contractor, and therefore the case is dismissed. Well, a few months later, the woman decides to sue her employer again, this time claiming that she's entitled to receive benefits, such as a retirement plan or insurance. This claim also turns on the issue of whether the woman is an employee or an independent contractor. So the woman will want to argue that she's an employee, not an independent contractor. The employer could use issue preclusion to prevent the woman from relitigating this issue of employee versus independent contractor, since the issue is already litigated in the first lawsuit, it was actually decided, and it was necessary to the judgment. Now that we've discussed the highly tested issues in civil procedure, the final tip is to practice. Many of these issues come up again and again, and there's a specific way that California law examiners often want you to address these issues in your answers. Practice writing answers with these issues to make sure that you're comfortable discussing them on your exam. Also, since civil procedure is tested on the multiple choice portion of the exam, practicing civil procedure essays will also help you become familiar with these topics for the multiple choice questions. To get started, you should look at and practice the civil procedure essays from February 2019, July 2017, July 2016, July 2015, and February 2015.